Hello there. This is An Architect Goes to Law School. Today in contracts class, we'll discuss dispute resolution clauses. AIA contract documents and other well-drafted contracts talk about many aspects of the contracting process and project timeline, in addition to the duties and rights of the parties. One such aspect is how the parties want to resolve their disputes. Dispute resolution's primary purpose is the enforcement of promises. Because the promises in a given contract range in importance from minor to major, dispute resolution clauses in contracts may treat different breaches differently. Some breaches, or even differences in parties' opinions and decisions, may be handled with informal dispute resolution processes. Other breaches may require litigation. As an alternative to litigation, some parties want arbitration to maintain the privacy that public litigation doesn't provide. Other parties want arbitration for its speed relative to public litigation. Other parties may want mediation for its relative simplicity. Many contracts contain multiple paragraphs and sections that detail how the parties to the contract will resolve their disputes, ranging from informal to public litigation in nature. Some of these dispute resolution clauses require the parties to provide notice, usually written, in advance of a more formalized dispute resolution process. It's a best practice for an architect to pay attention to these dispute resolution and notice sections of their contracts, familiarizing themselves with those sections, and deliberately choosing preferred methods of dispute resolution during contract negotiations. One aspect of a well-drafted contract's dispute resolution section is a choice of venue clause for when dispute resolutions happen. For example, an architecture firm situated in Los Angeles that's working on a project in Kansas City for a New York-based corporate property developer may want to include a choice of venue clause in the professional services contract. This clause would direct the parties to engage in their dispute resolution actions in a selected location, which may or may not benefit one party to the other's detriment. In this example, having the two coast-based entities meet in Kansas City might alleviate concerns of a home field advantage and spread the cost of travel among the parties. Making the choice of venue the location of the construction project is a common selection. Alternatively, depending on the contract negotiation process, one party might be willing to cede the point in order to preserve another contract aspect that party desires more. This would be part of the negotiation phase of the contract creation. Again, it's a best practice for an architect or architecture firm to familiarize themselves with the terms of a contract prior to executing it, and make deliberate decisions with regard to choice of venue clauses. No party to any contract should be surprised about anything they have agreed to and signed. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up in contracts class, we'll talk about the merger clause. Thank you for watching An Architect Goes to Law School.